Hello, you beautiful human. This is the 187 Said podcast, and I'm 187. The 187 Said podcast is a podcast for men, those who identify as men, and those that care for them. I'm producing this podcast to normalise the conversation around many of the topics that have an impact on men. If you're finding the episodes helpful, then feel free to support me by sharing the podcast, talking about the subject, or even getting in contact with me and letting me know what subjects I should cover. But also, if you have a lived experience that you think is important to talk about, or something you'd like to share, all of my contact details are in the show notes. Okay, so thank you for tuning in for another episode of the 187 Said podcast. I listened to the last episode, Your Ex Has Stopped You Seeing Your Children or Kids, and there are a few things I kind of need to clear up. The gist of that episode was really for you to get your head in a less emotional state, which is very difficult, but to get basically your action should not be mainly driven by emotions, more evidence, facts, and a more objective approach. Sounds quite clinical, but the reason is, as a man or somebody who identifies as a man, there will be preconceived ideas about you as a human being. Nobody will really know you, but they'll have because you are not the mum, then you may be seen in an equal, an objective way. We know what the majority of the country think when it comes to where children should be, and so we have to focus on the facts, not what we wish the world to be, even though we've got the Equalities Act and everybody's done diversity training and so on and so forth. We have to kind of accept that actually the legislation and the courses and everything are in place because there is unconscious bias, racism, sexism, inequality between genders and so on. So it is there. So we definitely have to make sure that we act accordingly, or make it as easy as possible for other people to make the decisions that they should do when it comes to your children. And I have to also note that there are instances, of course, that same-sex relationships break down and will be prevented from seeing their children. Another layer of what the world thinks about that come into play as well. And the dynamics in a same-sex relationship are going to be slightly different. Will be very different in regards to how we manage the external influences in making decisions about where the children should stay, or where the children should live and who they should see. Well, that's what essentially the court will be helping both parties to come to an agreement on. Also, I'm very aware a person who was born or assigned female gender at birth and coming out, or a relationship breaks down because they are now trans men, and will be told that it's unnatural for them to spend any time with their children. There could be lots of issues or controversy about that, but I should imagine that regardless of what a parent decides to do or be, the child is entitled to have that love and protection from that parent. Now what I've decided to do for this episode is to I think I'll make the episode a bit longer than the previous ones, kind of slow down and relax more, and give you all of the information you possibly need, from understanding what you're getting yourself into, the forms to fill out, the relationships that you will have through your journey of trying to fight for your child's rights to have contact with you. So one of the things I wanted to clarify is the landscape, i.e. the situation that you're getting yourself involved in. It's not a case of you just applying to court and getting a judge to decide where your children live and who they see or when they see you and so forth. What you have to appreciate is that there are a number of relationships that will take place that will have an influence on how you present your case. Now, one of the things that I tried to allude to in the last episode was that if there is a reason why you should not see your children, that you be honest with yourself and see if you can do some work to remove or reduce the risk. So, for example, if you are, let's just say, if you are, for example, a lorry driver with an alcohol problem and you regularly drive under the influence or slightly under the influence, or after, you're still under the influence when you're driving the next day, and although you haven't got any criminal convictions for it, that you do something about it to remove that risk. If you have been generally quite aggressive, abrasive in the household, if you punched holes in walls, or if you're a bit shouty, accept it, do something about it, move on. Whatever it is. If you have, if you have a violent offence that happened during or before your relationship, or even if you were abusive in your relationship, I think you also have to accept that's what you have been doing and do something about it. So it's all about you reducing the risk to your children. Now, people may say, well, I wasn't convicted of it and I don't have a record, blah blah blah, and make excuses. Fair enough, make excuses, but the fact is, if you know that you've done something wrong, that's been raised, then you can spend your life arguing the toss about it. But doing a course, getting some help, going on rehabilitation, speaking to a probation officer, going on a parenting course, managing your addictions, or being open and honest and transparent, doing that means that everybody is less worried about what you could possibly do. I could possibly hear half of you say, why should I do it? And then there'll be another half saying, well, yeah, I'll do that, but what's the point? She will do this, you will do that, they will do this, they will do that. The fact is, what we've got to understand is that we need to make it so easy for those people around us, or those organisations around us, to allow this contact. So that's what we need to do. We need to make it so easy for them to make a decision in the child's favour to see you. And you're not going to get that but by being obstructive or denying something that you know to be true. Conversely, I have met many fathers who want to see their children, and the partner has cited that they've been domestically abusive in a relationship, and the father has then been told, if you do this domestic abuse course, we'll see how we go from there, but you have to do this course, otherwise you won't get to see your children. They may not say that, but if you feel that if you don't do this course you won't get to see your children, find another course that doesn't mean you have to put your hands up and say that you've been domestically abusive. If you haven't, that is. And you may not be convicted of it because it never happened, or the police may not have been called. But the fact, if it's raised and it's true, then do yourself a favour, deal with it by admitting it, putting your hands up, and go and do something about it. If you want to know what you can do about it, then drop me a line and I can tell you. I don't have a problem doing that. I've worked with male perpetrators of domestic abuse for probably 13 years, and I know it inside and out. I know exactly what you probably need to do. So get in touch. But if you have, then get on that course and do it. If you haven't, however, if you have not been abusive, and you have to be honest with yourself about being abusive. We're not talking about, well, if you've hit someone, or we're not just talking about that. We're not just talking about you being physically abusive. We're talking about if you haven't been emotionally, sexually, financially abusive, if you haven't isolated that your partner, if you haven't gaslighted them, if you haven't done anything that's abusive. And again, you can go back to the podcast about the Domestic Abuse Act And if you have done any of those things, then fess up. But if you haven't, then don't go on that course, because there would be other obstacles to come about if you do. You don't have to agree to a lie just to make it easy for everybody else. The majority, most of the offences against women and children are perpetrated by men. It just is a fact. We just have to accept that it is a fact, and we need to do something that will prevent perpetrators of any violence, domestically or otherwise, from getting away scot-free. It may sound like you're shooting yourself in the foot, but you have to give context to your story and be full, open and transparent, even if it makes you look terrible. And the reason why I tell you this is because I've also been in the same position where somebody has finished their program as a perpetrator of domestic abuse, has honestly detailed the learning that they have, hadn't seen their child for almost a year, and agreed, because of the things he realises, not just the reason why he was arrested and convicted and put on this program, but other instances throughout the relationship, and his relationship with, or his sense of entitlement within relationships, was not okay and didn't work for him. He examined his mother and father and how they related to each other, and he knew that that he was to a certain degree replicating that behaviour in his own family. And in that case, as someone who had been abusive to a partner, was soon able to co-parent and move forward and see his children. So, or if you have been abusive, do something about it, and if you haven't been abusive and allegations are made, then you need to have these allegations looked at. And it may take longer through the courts, but do the work, you'll get out the other end and eventually get to see your children. That's one area. Now we're going to move on to the relationships you will have. So the key relationships you may have, main relationships. So the solicitor, CAFCAS officer, and your judge. So first of all, let's start with your legal team or your solicitor. Right. So before you've even decided that you're going to fill out a form and you're going to go to court in order to get contact, you have to make a decision exactly what you think you will offer, or you would like to offer your children. So saying things like, well, it needs to be 50-50, it should be 50-50, blah, blah. But if you cannot offer that, do not ask for it. You have to think about what you think the children would need. So if your children will benefit from having 50% of your time, or 40% of the time, or 30% of your time, that's what you go for. It's not about what you want or what the rest of the world thinks you should do because it's not right, or because you're entitled to half of them. You basically apply for what you would like the children to have from you. So if you can only do every other weekend or once a month, you put that down and you put the reasons down. You ask for that and the reasons why you're asking for that. If you feel that they are at risk, honestly, not because of your ego, because your ego is damaged and you feel you're entitled to do it, say, well, I want full custody. You're not thinking about what the needs of the child is, unless, of course, you truly wholeheartedly believe it to be the case and you have taken an evidence-based approach, i.e. you've got evidence to say that children will be better off with you, then fill your boots and definitely go for it. But don't make a decision based on your ego or what your mum and dad, what your friends think, or they say to you, oh well, ask for 1 day a month because you're not going to get much anyway because it's all biased in the women's favour. Forget all of that. Just go for what you honestly believe to be true. or what you honestly believe your children would benefit from. Right, so you've got to make that decision, and that's what you take to the solicitors. And one thing I forgot to say, actually, before you even go to court, you're going to have to, there are some exemptions, but before you go to court, you'd have to mediate. And as I say, there are some exemptions, so I'm not going to talk about that now, but you'd have to mediate, or actually show that you, with a third party, that you've come up with a solution to having no contact, and you put it to the mediator, and the mediator will invite the other party to basically, and the other side will make a comment as to what you're offering. Now, when you put your case across with the mediator, you're going to get one of three replies: yes, no, or maybe. Okay? If it's a yes, then you take that yes, you have it written down, you agreed, but as what's mediated is not, basically it's not bound by law, it's just like an agreement, you can take that to court and get a consent order. And there shouldn't be any problem doing that because you both agreed what's going to happen. So you just have an order made up of something that you've agreed, right? 2, if it's a no, with no other offer, so if the other party doesn't come back and say, well, no, you can't do it this, you have to do more or less contact or no contact, or yes, you can have contact, but it needs to be a contact centre or whatever. If you can't agree with that and it's a no, if you don't agree with that, then you go to court and you go for a child arrangements order or whatever else it is you're asking for. So it's yes, no, or maybe. And a maybe would be yes, but if you do this. And if you don't agree to those terms, then you go to court. If you agree to those terms, then you get a consent order at court. So all three of them means you will then eventually go to court. One, to hear it out for the court to help you both make a decision, because they're not going to make a decision, and I'll talk more about that. And 2, to have your agreements rubber stamped. As simple as that. Right. So you'd have to mediate to some degree, and maybe that person, the other party, doesn't want to mediate, in which case that's fair enough, nobody has to, it's a free country. Or then you go to court once you've got your relevant certificates and so on. And again, you want more information about that, get in touch with me and I can forward you onto an organisation that could possibly help you do that. Right, so from that you might want to have support with a legal team. Doesn't always mean you need to go to a solicitor to get this advice, but you might feel more comfortable with it. But you have to also remember, it's a solicitor also lives in a house that has gas and electricity, and they have to drive to work and they've got bills to pay. They will charge you accordingly for all the time they've been at university and opening a practice or being part of a practice. That's their objective, is to sell their skills for money. Now, if, for example, you are getting advice from a solicitor over 3 months and you don't get to see your children, you still get a bill. If you're for 3 months and you do get to see your children, you will get a bill. And they're likely to be the same amount of money, and they expect you to pay that bill. They will charge you for all the work they do. So they will bill you for the hour, and sometimes you can pay a solicitor from £80 to £500-600 per hour. So you need to factor that in. So don't think you can just phone a solicitor up and have a friendly chat with them and it'll be fine because he's a nice bloke or blokeess. You instruct a solicitor. The solicitor doesn't instruct you. They can advise you and you decide whether you're going to take it or not. But sometimes, in my humble opinion, sometimes a solicitor can encourage you to do things that prolong a process. It benefits them financially. Sometimes you can ask the solicitor a question, they'll say, I'm just going to write to the other solicitors. They write a letter or send an email, and then an email is replied from the other side who is also got the same objective, and that transaction, just that email alone, could, and I've seen examples of charges of £35, £60, and I've seen £120 for an hour to send an email. So that's sending an email. That's the solicitor talking to their assistant, the assistant sending an email, and then chasing up a reply, and then the other side replying, and then the assistant sending the solicitor, and the solicitor telling you or telling the client. Now that's an hour, and that's 150 quid. So there's a lot of work that's done that you could possibly have done yourself that doesn't really take any legal expertise because an assistant's done it, but it's still 100 and whatever pounds. The fact is, they've got bills to pay, and we kind of have to accept it. So you either pay the piper or you do the work yourself. And lots of people have been a litigant in person. All you have to do is search for that on the internet, and you'll find out exactly what that is. And you can do most of that yourself. And I've known lots of dads who have done that exact same thing and have called in a barrister, which is a bit like getting a sniper in, given all the paperwork, and then got contact with the children. It's been a hard slog. It means doing quite a lot of the legwork yourself, but sometimes when you pay, if your bill is 10, 20, 30,000 pounds, and you work out that actually, if you're thinking about having a solicitor about 5 times, a barrister in court is about 5 times, so that could be about 15, 20 grand if you get a relatively inexpensive barrister for that number of court appearances. Then the rest of that is just somebody doing your admin and information that you could possibly get yourself. Now, I'm not downplaying what a solicitor does or stating that, as if they're sort of ambulance chasers, but you have to be aware that you are in a vulnerable situation, and people will tell you stuff so that you play along. Trying to get contact with your children is a gravy train where even organisations that are there to protect fathers are charging a subscription fee and telling you to do quite aggressive things to have that contact. Again, if you are asking for advice from an organisation that is supposed to be quite supportive of fathers, and they're asking for a subscription fee, then you have to think, well, actually, hold on, what generally happens to men who are trying to have contact with their children? Sometimes they're not even living in the house and they're paying 2 mortgages, or a mortgage and rent. Some of them are living in cars. Some of them are managing mental health issues because of it, or they're drinking a lot, or other vulnerabilities arise, and they are taken advantage of. That's in my humble opinion anyway. There's loads of people who would just take advantage of you. So be wary of that. There are several organisations that can offer you the support you need, and if you are having difficulties, then feel free to, as I say, get in touch with me. Just send me a WhatsApp message or a voicemail. We'll have a chat and I'll direct you somewhere, depending on where you are in the country, England and Wales. If you know of an organisation in Scotland or in Ireland, then let me know and I'll pass that on once I've had a chat with them to see whether or not they are supportive of fathers. Okay, so we're talking about solicitors. So they do have an agenda, or they do have an objective, and that is to stay in practice and to make sure that they get the clients what they want. But if they've advised you that actually don't go for 3 days a week, just accept a video call, or you can write letters now, that's fine. You're paying £6,000 or more just for somebody to get you the opportunity to write a letter to your children. That, my friend, is bullshit. If you haven't done anything wrong, then you need to fight it. And that's why I'm saying, not that I'm offering you advice, because I can't offer any kind of legal advice on this, but I've seen many dads that have done a lot of the footwork that solicitors would do and being able to have contact with their children. So it's completely up to you, but bear that in mind. And when you do instruct a solicitor or barrister, you say, these are my goals and these are the goals that I want you to fight for. And you want to set up strict parameters or a protocol or way of working that fits your pocket. So if they're sending emails left and right and charging you 30, 40, 50, 60 quid per email, then perhaps you don't want them to do that, because it'll be the small things that cost a lot of money. You might want to find your own barrister rather than have that instructed by your solicitor, because they may benefit from who they instruct. Well, that's another thing to consider, should I say. Right. So that's your legal team. So in short, be clear about what you want, but also be clear about how your children will benefit from it, and be honest with yourself. If you lie to yourself, or if you're ego-led, people just pick the skin off your bones and have every penny out of your pocket. If you're very clear and honest about where you are or what you want for your children, then you should have no problems telling your legal team, this is what I want and this is how it works. Be very clear about how they manage your case, and say that you're very budget sensitive, and ask them how much they charge for emails, how do they respond, that sort of thing. You ask them about the list of potential charges that come up, and say, because you don't want them to just take a cavalier attitude regarding your money because of your financial position. They will also ask you to pay an upfront fee or a retainer, whatever it's called, which, if that's the way they work, you have to pay the piper. You should have a conversation of, I've just given you £5,000, don't just spend it willy-nilly and then come back to me for another 5, because it's not going to happen. I need to know what you're spending it on. And not, for our services. No, I need to know. A stamp on a letter, I need to know about that stamp on that letter. And if you have an argument with the solicitor about that, and airing your concerns and they're not working with you, get another one. Times are hard. We can't have you just laid out like an injured wildebeest with vultures just flying around, because whether you're dead or not, they will just literally come and pick bits off your bones. They just will. So don't allow that to happen. So that's your relationship with the solicitors that you kind of need to manage. Another important relationship is going to be with what's called a CAFCAS officer. It's a Children and Families Advisory Service. And essentially what they will do, that if the court instruct them to, they will write a report, which means they will have a chat, a conversation with mum and dad about the children. So generally, initially, when they are appointed, which will be before you even go to court, you'll have a conversation with the CAFCAS officer. Now, remember you're talking about unconscious bias? The mindset for everybody involved will be, we are not going to change where the children live if they're fine where they are. If it's not broken, we don't fix it. So be aware that on occasion, this may not be the case for you, but on occasion, CAFCAS officers will phone the parent that has the children first. Even though you've made the application, fair enough. But what can happen is, because of unconscious bias, that individual could decide that what is being told is the narrative. That's the basis from what they're working from. And they may get reports from various other places, like the police and so on, and the narrative that the person with the child could sometimes be the narrative that the officer will believe. And they'll believe it on the basis that, in their mind, part of their upbringing and the way they see the world is that mum knows best. Children should be with their mum. Or a good healthy relationship is mum and dad and the children, and dad's gone, so it would be to make sure that mum has the children. They could potentially just listen to the narrative from what the mum's saying. Now, when you get your call from the CAFCAS officer, don't have and I'm going to say this with all love in my heart, don't answer the phone with a chip on your shoulder to rubbish mum and say she's got mental health issues and point all the problems and she's doing this and she's doing that. Don't do it. Don't be combative. Do not say anything that you wouldn't say in front of your child if they were sitting there and you were talking about the other parent. Don't do it. If you have honest concerns about your child's development and the way that they are living, then you can raise them, but make sure that you've got evidence of it. But more importantly than that, it's about your child's needs and how you can meet those child's needs. And it may be that you've got the issues that I presented before, something criminal, something violent, something abusive, something negative that comes up. And as I said before, if it's true, put your hands up, admit it. If you, hopefully by that time you've already done something about it, and what the benefit is now that you've done something about it to the children. So for example, if it is that you get this phone call and you've been told that you've been domestically abusive, and you say, yes, I have, these are the circumstances when they've happened, open and transparent, I've been on this course, I've been doing this, and even though I know that there is a concern, I'm quite happy to see my children in a contact centre, and I've organised these contact centres, or my brother or somebody else will be able to supervise, or whatever it is, because clearly if you've caused some sort of trauma within the house, not just with the parent, but the child will be traumatised, whether they were there or not. There will be an impact on them because of the abuse in the house. That's without saying this, without argument. You just have to accept that that's the case. That even if your children were not there when you were being abusive, they will be impacted by what's happened. And again, we'll probably touch on that on another episode. But they will be impacted, and you just have to accept that and do something about it. And also accept that you can't just go in and go, right, well, I want my children full time because of that, because nobody will listen to you. Focus on the needs of the child. Focus on your parental responsibility to effectively co-parent in a safe and meaningful manner. That's what you have to do. So your job is going to be, when you speak to the CAFCAS officer, is to show or to outline where you were in regards to how the family was set up and what your thoughts were or beliefs about it, what your thoughts and beliefs were about it, how you broke up, what your thoughts and beliefs were about that. Now you're broken up, what your thoughts and beliefs are about that. And now you want to build or co-parent in a different way with your partner, and what your beliefs, with your ex-partner, and what your beliefs and attitudes are about that. And how each of those stages have had a negative impact on the children, and I suppose had a negative impact on you, and also your understanding as to how it's had an impact on the other parent. And out of all of those, what you're prepared to do or what you have done already. But everything needs to be child focused. It's not about you and the fact that she's done something that's kind of really upset you, blah, blah, blah. It's all about the children. Except if you are a victim of domestic abuse, which means you probably wouldn't have gone through mediation anyway, and you've gone to court, you would have outlined that in the court documents, and the CAFCAS officer would have seen that, and then you just relay an evidence-based dialogue around the things that have happened during your relationship. Now, I'm asking you to ensure that you do not try to reduce the amount of emotional language when discussing it. Even if you say, this is very emotional to me, but I'm going to try and make sure that you just get the evidence. It's not about my opinion, it's about what's happened. Because in regards to unconscious bias, if you think about what's expected of men in regards to how they behave, there's a term, toxic masculinity. Phrases like boys will be boys, men are aggressive, men are demanding, men are controlling, the patriarchy, everything that's there. You will have to measure your tone, measure your thoughts, measure your emotions to get to where you need to be. Now that call will probably last 15 minutes to an hour. If it happens much longer than that, that's because the officer is asking lots of other questions and probably wants more information, and you want to just make sure that they have the right sort of information. That is a small period of time for you to have to just focus on your child and less about what's been done to you that's not okay. So you need to get through that call so that when a report's written, it sets out your facts. Now, what you have to remember, if you've done the best you can, you've done the best you can. The person, the Kafkas officer, will write a report, and they will not include everything that you said or anything that you feel that should be in there. And they probably will also do the same thing with the other part, with your ex-partner, not include everything that she says. But you're hoping for a report that is objective and evidence-based. If it is littered with opinions or things that are not true, again, you go through it, you highlight it, and you write a response however you wish to do it, either to the court, to the officer, or whatever, and say, thank you for the report, but da-da-da-da-da. You don't want to get into proving that people are wrong. You don't want to make people feel that their professionalism is called into question. What you are doing and what your mindset must always be with both with the court and when you present facts with the court and when you present facts is to be collaborative, supportive. Everybody is professionally focused on the needs of the child. So on that basis, they're doing the same job as you. Your job will be to support them and give them the necessary support in order to produce the right documentations and help the court come to the right decision. And that's where we move from your Kafkas office to the actual court and the hearings and so on. The phrase, I'm going to take you to court and the court will make you do X, Y and Z, is a misnomer. Courts don't make the decision unless both of you can't come to a decision. They want both parties to sort it out and come up with a conclusion that they can just write down and rubber stamp. They don't want to make a decision based on who has the children and where they live unless it's blatantly obvious that there is not going to come back and bite them in the arse in 6 months or 6 years' time. No judge wants that on their record. So that's why I'm saying that you must be collaborative and supportive with everybody who is invested in the rights of the child to spend time with both parents. So your job is to make it easy for the court so that it's just so obvious that the children have spent time with you. And you're not going to have that if you are being combative or you're being obstructive or you're fighting for fathers' rights all up and down the country. This is your moment to focus just on the children. When somebody is taking their eye off it and just saying, yes, well, Dad may say that. No, actually, the parent with equal parental responsibility is saying this. Okay, so it's about being assertive, not being domineering. It's about, as I say, and I'll say this again, supportive and collaborative. If you can't say something nicely, don't say it at all. If you think that something is a blatant lie, you don't say she's a lying cow and she's just making it up to make me look bad. You know that. You don't need to say it because it sounds like you're just being argumentative. But it's enough for you to say, I can see why she would say that because this incident happened. However, this is the context and it's in the report, blah, blah, blah. Or I don't understand why she thinks that because the children have spent this amount of time with me. It's only now that I'm in a new relationship that things seem to have changed. I'm quite disappointed by that, but it's not really relevant to the needs of the child. Or I don't feel it's relevant to the needs of the child. What do you think? So, supportive and collaborative and measured responses that always focuses on the needs of your child, not your needs. And that's really the only way. And it's going to take a long time, but that's the mode you have to be in to make it as easy for the court to make the decision. well, actually, no, not for them to make a decision, to make it as easy as possible for the court to accept that what's being presented is the best for the child. So, just roughly recap. So you're going to have a relationship with the solicitors. Make sure you're paying them a pretty buck, and you need to make sure that they not only advise you properly, but that they have the same goals as you do when it comes to your case. But you also have to make sure that if they've got the same goal, that they don't spend your money like they're just trying to get a new conservatory or a new holiday booked. You have to know what your money has been spent on. Also, you could do quite a lot of this without a solicitor, but I would say you definitely, at certain key points, may need a barrister. So you need to research that and make sure that you roll a barrister in. And again, there are organisations that can help you that won't pick the flesh off your bones and ask you to pay a subscription to just being on their books, because that's not okay. And if you're going to pay anyone for legal advice, get it from somebody who's certified and on a register for being a solicitor or a barrister. As much as you can get people who are kind of like a legal friend that can attend court with you, or an advisor, if you're paying them the amount of money to do that, see if you can find an actual solicitor who will be held accountable, that will have indemnity insurance, who will be legally obliged to make sure that they behave in a particular way. Right. If you're not a solicitor or barrister, you can't be sued for being given incorrect legal advice or being advised incorrectly. So there's no comeback for somebody who's not accredited by it and doesn't have indemnity insurance, or they don't have, or should I say, anybody can get insurance, but they don't have indemnity insurance that you could claim back on. Alright, so be very careful about accepting legal advice from anyone who's not qualified. So that's your landscape. Each person will have individual requirements, but your main relationships will be with a mediator if you need to have one, a solicitor if you need to have one, and or a barrister, and then the CAFCAS officer if you need to have one. I would say that there are other relationships that you should already have in place before you even decide to, throughout your life of having a child with someone. So if you're in a family, as a father or as a parent, you should have a connection with the school, the GP, the midwives and so on. And if you don't, let's say for example, we'll talk about it being a new father at some point, but if you don't, you need to have those that are key, because the fact is you've got the same parental responsibility as the mother with that. And if something happens to the children, you can't just go, oh well, I didn't know. So you need to be involved in the school, you need to be involved with the nursery, you need to be involved with a health visitor, you need to know about all the special needs that your child may have, if they're autistic or have asthma, got a wonky leg or the ADHD, whatever it is. You need to learn these things. So, but that's another episode. Make sure when your relationships break down, if you already have those relationships, make sure that they're maintained, because why wouldn't you? Right, so those are the main relationships, and that's the landscape. So accept that there is to a certain degree unconscious bias. Some people are vehemently against fathers exercising their children's rights to have spend time with them, and they hold positions in places that are not helpful for them to be in. Right, but they exist, and you kind of just have to manage that by not by fighting, but by being collaborative and supportive, making it very difficult to not do the right thing. And we talked a little bit about the process. So, and I'll just reiterate that, so I don't have to do a separate episode. So the process is this: you want to see your children for X periods of time in a particular place, and you want them to live in a particular place and see you at this, whatever you want for your children. You've already come to a decision with that. So you would have to go to a mediator. Then from a mediator, if it's yes, no or maybe, well, you can go to court. You won't be able to go to court unless, of course, you're able to say, we've tried to mediate and it didn't work. And the only circumstances where you don't have to mediate is if you have been a victim of domestic abuse. Again, I've mentioned, we've had a couple of episodes of that, looking at that fact of male victims of domestic abuse, which you might want to listen to. But in short, find out what domestic abuse is, and if these things are truly part of what's happening to you, make sure you report it. Record and report. Report it or record it didn't happen, as far as anyone's concerned. And that, and people might, in their minds, will say, you're a man, she's a woman, can't happen. Or it's not that bad because you're a man. Or you don't have any bruises on you, but... So these things that are happening to you are not that important. The coercive control, the financial abuse, the intimidation and verbal threats and that kind of thing. It's not that important because you didn't get hurt. She can't physically hurt you, so what's the problem? If that is happening to you, find someone to talk to about it and get it recorded. You probably won't have anywhere to really go for it, because for help, that is just for men, because there is literally only one place that I know that can support male victims of domestic abuse, and is run by a service that's dedicated to supporting men. So not a domestic abuse service that predominantly supports women and then supports some men. I'm talking about a service that is there to support men. Don't think that either exists. If it does, let me know. I would love to refer people onto it, to be honest with you, anywhere in the country. So, and when I say in the country, I'm talking England, Scotland, Wales and Ireland. So you mediate and then you go to court and you fill out a form. I think the form now is just called the C100 and the C1A for you to, and the C1A section is for you to talk about any kind of physical, emotional, financial or coercive controlling behaviours or any kind of abuse that you suffered within a relationship. So this is where you get to tell your narrative, the way you see the relationship, how it ended, or the impact it has had on you, but in relation to not just your emotional state, but how has it impacted on your parenting. Remember that if you're a victim of domestic abuse, so are your children. So talk about the psychological impact, all the impacts that on them, and how you want to equalise that by playing an active role within your children's life. You'll do all that paperwork, so you filled your C100 out, and with the C1A and any supporting documents, that goes off to the court, and you have to wait for a court date. And on your court date, the first hearing, is pretty much just going to be the court agreeing who you are, who your ex-partner is, the children, make sure that that's right, what we're talking about and what you're asking for. So on your form, and I'll have to find a link, which if I do find it will be in your show notes, that will detail where you can find details about how you fill out the forms for that. And in the form it will say, what do you want the court to do? So whether you want them to make a consent order, or if you want them to not allow the other partner to do something, if you specifically want to make sure that the children are or are not circumcised, or don't choose a particular school, do not move out of the area, whatever it is, there's something specific thing you want them to do or not do, then that you can mention that as well. Something you want to stop, anything you want to prohibit, you can do that as well. So you can't take the children out of the country for more than a month, or you can't re-register them to another school without me knowing, that kind of stuff. Those can be put in an order. So now you know what the landscape is like, you know the relationships that are important around you, and you know that it needs to be directed by what you believe to be focused on the needs of the child, and not your own ego or your anger or what you feel your rights are. It's all about the child. I don't think there's much more for me to say. So if there are any holes or any questions that come up, then please get in contact with me. I hope you found this useful. I am learning to podcast. I think hopefully it'll start improving, but hopefully the content in itself is helpful. So let me know what your thoughts are by subscribing, because this is not a weekly or monthly podcast. It's just as and when something comes up. 5-star reviews, that would be great, and then write a comment. I'll have a 5-star review, but if you want to complain as well, I'd read those, and I will take note of what you've actually said. If you've got a lived experience that you want to share, then get in touch with me. Really like to hear from you. And just to let you know as well that the first Sunday of every month there will be a Google Meet session just for an hour, and it will be at 7 minutes past 6, which is 18:07. Thank you for listening to this episode, and wherever you listen to this podcast, please subscribe, like, or leave a comment.